Good afternoon. If you're looking for LA FOIP Foundation's access and privacy tips for local authorities, specifically for police services, you're in the right place. So thanks for joining us this afternoon. This is the fourth in the series of webinars that we've been offering on LA FOIP this week. And if you were here on Monday, then you've already been introduced to me. I'm Diane Aldridge and the moderator for this afternoon. I'm the Executive Director of Compliance with the Office of the Information and Privacy Commissioner. And specifically, I work with the analyst team, which includes the manager of compliance and the analysts that do reviews and investigations. And before I introduce our panelists and get into the housekeeping, I just wanted to provide a little bit of background and context to make sure that we're all at the same starting point. So first off, this afternoon, we're talking about the Local Authority Freedom of Information and Protection of Privacy Act. We call it LA FOIP for short. That's the acronym. And it's an access and privacy law. And we call it an access and privacy law because there's two primary parts. Part 2 deals with access to information or access to records, and Part 4, which is about the protection of privacy, specifically personal information. And in this particular case, we're talking about police services, a local authority. But even though LA FOIP has been in force since 1993, so a really long time, police services weren't brought under the Act till January 1st, 2018, because we had some significant amendments to the Act at that time. But also to be clear, what we're not talking about is the Royal Canadian Mounted Police. The RCMP are actually bound under federal legislation, the Access to Information Act and Privacy Act, and our office doesn't provide oversight because we are the oversight body. People come and they complain if they feel that access was denied and it shouldn't be, or there's a privacy complaint about they feel like their privacy was in breach. So it's actually the Information Commissioner of Canada and the Privacy Commissioner of Canada, respectively, that provide oversight in those specific cases. So now I have the pleasure of introducing our panelists, and we're in very good company today. First, Rick McKenna, who has over 37 years with the Moose Jaw Police Service. And Rick, he's crying. It only gets better over time, right, Rick?
Sounds worse when you say it.
He's the superintendent with the Special Services Branch, which includes the role, lucky him, of LA FOIP coordinator. And he is responsible for establishing its LA FOIP program and ensuring the service's compliance with LA FOIP. And that was also through the development of policies and procedures. And secondly, Ashley Smith. Ashley received her LLB from the U of S in 2007 and hasn't slowed down since. After making notable accomplishments, and she landed the role of Director of Legal Services with the Saskatoon Police Service. For more complete bios, please visit our website. I think they're still there on the page where you found the information to sign up here. I'm not sure how much longer I'll be up there, but it's up there right now. So now the housekeeping. We have an hour and a half allocated for this session, and we definitely want to hear from you. But you probably noticed already, you're muted. You're in listen mode only. And so if you have a question to raise, please put it in the question pane, which I will be paying close attention to. But before we get to your questions, we do have some pre-arranged questions that we've already decided to start with. And as soon as we're through those, time permitted, we'll get to as many on the list as possible. And if not, which one of you two are going to volunteer to field the questions after the fact? Hands? No? Oh, I'm sure everybody's available. I also want to let you know that this session is being recorded. So if you missed something or want to revisit it, it will eventually be available on our website. Not sure when that's going to be, but if you follow us on Twitter, we will send out a tweet at some point, or I'm sure if you just visit our website on a regular basis intermittently, because there's always so much interesting information there, it'll be under the What's New tab or What's New section of the website. And finally, immediately following the session, I encourage you to please fill out our post-webinar survey. It's only 5 questions for a multiple choice, so you should be able to click through it really quickly, because we really value your feedback. This is our first attempt at these webinars this week, and we only want to improve and make sure that we're being responsive to your needs. So please do that. All right, without further ado, we're going to get started. And the first question is how did you get involved in the access and privacy area? And Rick, knowing you, because you're so enthusiastic, you probably put up your hand and said, pick me, pick me.
Yeah. Well, it's a funny story. When I was the president, years ago, I was the president of the Moose Jaw Police Association, and we'd actually made a complaint to the Privacy Commissioner's office in regards to publishing of police wages by the city of Moose Jaw. Our purpose was that we felt under the LA FOIP, the city, not being our employer, didn't have the authority to do that. We're actually employed by the Board of Police Commissioners. So correctly, we felt they should have been the ones publishing our wages. Anyway, the Privacy Commissioner investigated and he agreed with us. And coincidentally, I think that decision is actually on your website, Diana. If I remember correctly, it's LA 2012-01. I might have that wrong, but I think that's what it is. Anyway, in that decision, he actually said the Legislative Assembly should be clarifying whether or not municipal boards of police commissioners or police services are or are not local authorities. And so that was fine and good. It was nice to sort of throw that grenade in the room and walk away. But you fast forward a few years and I become an inspector. I'm out of scope now. I'm no longer in the association. And we're coming under the act. And Chief Rick Barassa calls me in and tells me that he wants to be ready for these changes. January 1st, he wants a program that is completely FOIP compliant, right down from policies, procedures, the whole bit. And he wants to demonstrate the importance of the legislation to both the members and the community by putting a ranking officer in charge of it. And the next thing I know, I'm transferred to the newly created position of inspector in charge of special services branch slash LA FOIP coordinator. And so that's how I got here. I was volunteered, I guess, voluntold maybe some might say. But the chief thought it was important that in order that we had any kind of investigations or breaches, that he have a senior member in there that could sort of take things from investigating it as a privacy breach to bridging that over to under the Police Act, because ultimately the way to discipline our members is under the Police Act. So you know, I said this before, for me, this on a personal level, this was a fantastic opportunity because it allowed me to change jobs, learn some new skills, and I got to meet some rather interesting people that were openly enthusiastic about their jobs and privacy issues, and that's actually kind of infectious. Certainly it helps extend the longevity of my career by being around people like that. And you know, I've always been a big believer in Peel's principles and the Charter of Rights and Freedoms, and it wasn't lost on me in my conversation, especially with the chief, that you know, the United Nations sees access to government institutions as a fundamental right. It's the only method really to build trust with your community, because it's the only method that a private citizen has to verify that institutions, government institutions in particular, are acting in the best interest of their citizens, that they're held accountable, and they're acting with ethics and integrity. So it's a nice fit. That's me.
What about for you, Ashley? Were you voluntold?
Well, it was an interesting process because when I was hired as in-house at the Saskatoon Police Service in the fall of 2015, this was not even on the radar. It had been discussed for years and years. I understood that police should come under the legislation or would, but there had never been anything specifically concrete. So until about June of 2016, that was the case. And then we were advised that legislation would be coming and that police would be falling under access to information legislation. So for the next year and a half, we were working on getting our policy together, training, identifying what that unit would look like, getting staffing in place and things like that. So it was determined that the Access and Privacy Unit would come under our Legal Services Division, which I had. And so it was a big of surprise to me as anyone else that that this would become a big portion of my day-to-day at the office. So thankfully, we hired a phenomenal access and privacy officer who is a privacy specialist, actually from the Office of the Information and Privacy Commissioner, and we're able to add on a junior privacy and access officer. So we have a slightly different situation than Moose Jaw because our access and privacy unit are all civilians. We don't have a sworn police officer as the head of that unit. So there are a few differences there. And yeah, and then we fell under LA FOIP, and the rest is history. So I can't say it's something that I thought would be part of my day to day, but now it's just an average part of the day. So it's been exciting. One of the most interesting things I've done so far since I started in this position, for sure.
And I guess just a follow-up question to that really briefly, how is the workload when it comes to access and privacy? How are you finding it in terms of, because a lot of people have to wear multiple hats. They're doing this, but then they're doing LA FOIP stuff on the side. How busy does this keep you, Ashley?
Well, I know our 2 access and privacy officers are incredibly busy. I think last year in Saskatoon, I think we had around 234 requests that we fielded just in Saskatoon. And then there's other responsibilities as well, auditing, privacy impact assessments, any appeals to the privacy commissioner, other information requests outside of LA FOIP that still need to be addressed. So they have a huge amount of responsibility and a lot of tasks that they're asked to take on. And of course, there actually is a lot of intersection with legal issues or agreements for the organization, information sharing agreements and things like that. So we're always, kind of intersecting on those types of things. So I would say that for the Access and Privacy Unit proper, it has been an incredible amount. They're amazing. They deal with so much and so much volume and responsibility. And whereas our legal department as well, falling under LA FOIP has increased a lot of what we do as well, because we didn't have the amount of information sharing agreements that we do now that we did in the past, and and the advising on privacy issues and things like that. Now that people are aware of it and thinking about it all the time because we're under the legislation, we do get a lot more questions, which is great. That's what we want, is people to ask and double check or make sure they're thinking about how we interact with partners. What information we share, or should this be the appropriate information that they share and things like that. So it's definitely increased the workload for both legal and access and privacy, but I think it also has brought a lot of improvements to the organization as a whole, because I do think that we are more transparent. Our members and all our employees are more aware of the importance of privacy, and they understand the access to information process now. So I think it's actually brought a lot of positive improvements. But I'm not going to lie, it has definitely brought a lot of work to the organization as well. So.
Yeah, because it touches on everything, and
Yes.
it's true. It's not just learning about, oh, well, it affects this and this, but also it's that culture shift, right? In terms of, we never thought of it in that context before. And Rick, what about you?
Yeah, exactly what Ashley hit on are sort of the big ones. When you look at the number of people that are actually applying for access to information, last year for us, I think we only had about 30 actual ones. But we have a lot of inquiry into them. But a lot of them can be dealt with through other, Stitchcomb. Some of them are actually, people come in wanting information, but it's actually covered under Stitchcomb, so we can deal with things differently. The big one really is for us has been agreements, or trying to get agreements with other bodies that we share information with. That's consumes a lot of our time. And then looking at our processes and where, things that we used to do that were at the time fine, now, not so much. policing was always, we always had that, that sort of oath of secrecy, but this has really changed. I would say this has really changed people's perceptions on how it is we're going to share the information. And it really, to me, my perception is that it's opened up a lot of doors with some of the government partnerships that we have, because now they realize, now that we're covered under this act, they know they can share the information with us, and we have a responsibility to protect it. When we weren't covered under the act, you really didn't, they really didn't know what we were, they had no control over what we did with the information once we had it. So I think that caused a lot of concern for, social services, medical, you name it. But now that we're covered under the act, and everybody's basically on the same footing, the rules apply across the board, it's a little bit easier to share information. Sort of the resistance has been those people that have enjoyed receiving information fairly openly, don't understand now that we need agreements in place to be able to do that. So that's sort of
because now that you're part of the club, there are those specific disclosure provisions in LAFOIB where a government institution can share with a local authority, or a local authority can share with another local authority. So just because you're part of that group now, it does allow for some additional sharing that wasn't necessarily there before.
Yeah.
Great. So second question, in your view, and I know, like you said, this access and privacy touches on everything, but if you really had to nail it down or narrow it down to 3 or 4 top of mind access and privacy issues that impact police services, what would those be? And let's start with Rick. Sorry, Ashley. You just spoke.
Throw me for a loop there.
Yeah, sorry.
Surprise, Rick. Yeah, well, I think, I think we're kind of at a turning point now with police services. We've had several years under the legislation. People are comfortable with what's an access request, how do we process that? We have good programs and policies in place now. And so now, I think we're kind of looking at that next layer. There was such almost a panic, you had a huge cultural shift. You had a completely new program. You had, you were educating the public, you were educating internally. And now that people are kind of comfortable, some of the things that are coming up, we've already talked about information sharing agreements, privacy impact assessments. I think no matter how much legwork we did before the legislation came in to identify every relationship, every partner, every committee the members were sitting on, things like that, we're still uncovering kind of relationships or situations where information was being shared that now we have to take that step back. So the information sharing agreements I know continue to come up. And like Rick said, messaging as to why we need those and why it's important for us to know what that partner or community stakeholder is doing with the information and protecting it and things like that. That continues to come up on a regular basis. The other thing is that, we may feel more comfortable with this process, but the public is still new to this. And education of the public continues to be something that comes up because there are a lot of misconceptions by members of the public of what they can get, how quickly they can get it, what they should be entitled to. And there are separate exemptions for police. So there's certain things that we can't release that are unique to us. And so, explaining to people that if this is an active investigation, we can't give you this information at that time. Investigative techniques, and some of these things that they never would have encountered if they had requested information from other entities. So we've tried to, at least in our organization, make it really as detailed as possible on our website, outlining, what people need to do, what they need to include, what they need for identity verification, some exceptions to disclosure, how long it will take, so that we're managing expectations of the public and also making it accessible. So we allow people to submit their requests online, in person, or via mail, and which also allows for multiple payment options as well for maybe individuals who don't have credit cards or have to seek outside, other ways of payment for a FOIP fee, etc. So, so that continues to come up. The other thing that has come up is now that we're more aware of the protection of these documents, you know, the importance of privacy, is a broader look at the information governance of the entire organization. And so what I mean by that is detention and, destruction and retention of documents, information mapping. So knowing what information do you have in the organization? Where is it stored? You know, who has it, who has access to it? Because one thing they're finding when you've got such a large organization, and especially with police, there's a lot of different databases, different types of information. You're getting information from lots of different organizations. You know, if someone is storing stuff in their personal email or on a personal drive, you know, things like that, is it properly making it to a file? You know, is information being put in 4 or 5 different places when it could be in one? You know, and also too, if you lose someone leaves an organization, someone retires, what happens to their information? So there's a lot of these very detailed items that in the panic to kind of get ready for falling under LA FOIP, you know, just wasn't as big of a focus as, do we have a process on how to get access, you know, access requests in and things like that. So that broader information governance has even a more importance now, because if we know where our information is, it's easier to gather records for LA FOIP requests. If we have a clear idea of the information in the organization where it's stored, we can better protect it. And also, we don't have a bunch of extra information we don't need that we now have this obligation to protect and things like that. So we're mitigating our risk as well, because we're not having extra information that we really don't need anymore. And we also are destroying information in a consistent fashion. So legal holds, for instance, so if there is litigation in the organization or potential litigation that people are being identified and saying, please do not destroy this information. Please ensure that it is kept for a long period of, you know, until we tell you it can be destroyed. You know, and also too, like limitation periods. Are you keeping your documentation for a period of time that if you do get sued, that documentation that may be relevant is still going to be available to you? Things like that, which is not really super exciting for a lot of people to think about. And but we're kind of moving into that next step, and doing that broader organizational review, I think, will even help us improve even more as organizations, police services across the province. And body-worn cameras. Have to end on that one, because
well, and we could talk for hours on that one.
So I'll leave it at that. I think that's a to be continued in the future.
Exactly.
But definitely is going to be the big thing coming up.
So a couple of things. There's some comments I want to share too from the questions pane, but just from having some experience when people aren't looking at, you know, their records and where they are, and ensuring that what needs to be destroyed is destroyed in a timely fashion, and you know, that you really have a good sense of what you have and where it is and when it needs to no longer exist. We had a number of cases of abandoned patient records back in the day where, you know, we found boxes that were 40, 50 years old, and you know, they were moldy and dirty, and you know, the physicians had left the jurisdiction. So then, you know, what do you do with this? And luckily, you know, it was the landlords that brought that to our attention, but you know, could have ended up in a huge privacy breach. So I'm glad to hear that you guys are doing that. Just a comment from the questions pane. So it's Murray from Estevan. Just wanted to make a quick comment regarding LA FOIP and how it is leading to changes to the Police Act as it relates to file retention. Those regulation changes are forthcoming. So that sounds pretty exciting.
Yeah, that's probably Murray Cowan, who's, I believe, the chair of that committee, because I'm on that as well. And retention, the SACP, the Saskatchewan Association Chiefs of Police has a working group that is looking at all our retentions, because of course there's the retentions come under the Police Act, right, for our files and stuff. Right. So not just retention, but also how we're storing it. And the big one, I mean, Ashley articulated it perfectly. The big thing is that, you know, police officers traditionally are pack rats. They collect information like it's a nugget of value at some point in the future. That's probably served well in some investigations and hurt us in others. But you never know what little piece of information might actually be that one thing that just blows a case open.
Mhm.
And so we in the past we tended to, anything that anybody was willing to give us, we would collect. I think now that we're into FOIP a bit, people are getting more used to the concept of collect only what you have a legal authority to collect, and collect only the stuff that's really germane to your case. But the problem exists that on a lot of our electronic record management systems, some of the information that we collected with consent, but probably don't have the legal authority to have, is already in our system. So how do you, how do you deal with that? And then the other thing is, because now you're storing things electronically. In the old days, you had a file room, and eventually you'd run out of space, and somebody would say, oh, well, this stuff's 20 years old. Under the guidelines, we can shred it. Now it's on a computer hard drive somewhere, and you've got all sorts of information, and you can keep a large amount of information for a relatively long time, fairly inexpensively. So there's sort of two schools of thought. Do we keep everything, or do we start purging stuff at the 5, 10, 15, 20, 25 year marks, whatever retention schedule we land on? And I mean, the Milgard case, I think, is still fresh in a few people's minds of somebody revisiting something 25, 35 years later, and how do you account for what was done when there's nobody left in your organization that was there, and all you have would be the records, right? So some police officers get a little apprehensive about destroying evidence, and but
yeah, we'll get back to the question that we started with in a second, but what just came to mind when we're talking about record retention, destruction, being pack rats, and keeping information that has evidential value, right? Because eventually it could be subject to a court proceeding. Police notebooks, old school, but still in use. And do you think people are really getting members are really getting their head wrapped around how that information needs to be protected and how it's stored?
I think they are now, because everybody's received the training. Yeah, up until recently, I think a few people thought that these are the kind of things that when their career ends, they're going to take home with them and, be able to go through and reminisce. But, all our notebooks are turned in when people leave the service, and they're filed here. Of course, the problem is that we're responsible for all records under our possession or under our control. And of course, the notebooks are work product, but we're so used to being able to just punch in a name into a computer and getting all that information.
Right.
Notebooks don't work quite that way. So now you've got to actually go through and read them. And different organizations are dealing with that differently. But now I'm seeing a lot more members indicate in the report, page 5 to 20 of notebook 15 for this event, so that in the event that somebody does do an access request and you're going through the report, okay, if I go to the notebook, these are the pages I have to look at it, rather than trying to read through a year of somebody's handwritten notes. And not every police officer is William Shakespeare. Their penmanship isn't necessarily the greatest, so that becomes a problem.
So back to the original question, because we've covered a lot of ground already. Were there any other top of mind issues, Rick, for you?
I think that actually hit on pretty much the same things that we have, the issues that we had. I guess one of the things that we are one of the little things that we struggle with is the personal information, the information that we transmit to our partners and how we send it. For instance, I don't, and just because I'm naming names doesn't mean I'm trying to be disrespectful, but SGI, we share a lot of information with SGI, and some of that information, you know, for prohibited drivers and things of that nature, it's timely. It has to, you know, pull somebody over on the side of the road and their license is suspended, we have to notify SGI right away. They prefer to do that by fax, but the problem with that is if our fax machine accidentally sends it to the wrong phone number, we're the ones in the privacy breach position. So it's up to us to rectify that. It would be a lot nicer, obviously, if we could send an encrypted email to one specific account. So trying to work with our partner agencies and get them to sort of change their practices a little bit when there's really, you know, it doesn't, they're still getting, they're going to get the information regardless. So we don't have a lot of hook in there to sort of force them to modernize. You know, we've been dealing with the city as well. You know, there's some services that historically we've shared without any kind of an agreement, and now, you know, we need an agreement, and there's a, you know, a little bit of reluctance there, especially when you're dealing with things like WCB or Employment Canada, and some of these things have caused us a little bit of an issue, but yeah, we just continue to, you know, I guess we just continue to have conversations and get to a good spot with them.
Mm-hmm. So I think we'll take a question from one of the participants. Does a non-police LA FOIP institution have the ability to exempt access to internal investigation records about an activity that might be referred to police for investigation? And then there's a second part of the question, could the exceptions for law enforcement investigations apply in this case? So about the same thing.
Okay, so just, I'm trying to get my head around that question.
Yeah.
So somebody from an institution that isn't subject to FOIP?
Yes, that's how I'm taking it too. So it's not a government institution or a local authority, and maybe they're passing on, you know, information that you're using in the course maybe of an investigation. And
Okay.
And I think what they're looking for is, you know, can they also rely on something to say, oh, this is withheld under FOIP or LA FOIP?
Ashley's probably the better person to answer that, but I'll say this. Well, you know, when we do the training, I tell our guys, just if somebody suggests to you that this is confidential information, you better explain to them that there's conditions to that. If the record, once the record is in our possession, there's a responsibility upon us to provide it. If it's a third-party record, then the act is specific. We have to notify that third party. I don't think the act cares whether that other third party is under LA FOIP or not. We are, and so we would probably notify them if there was a reason that to withhold it. If it was an event, as Ashley talked to earlier, if there was an investigative technique at risk, or if it was an ongoing investigation, we would probably withhold that. But is there a carte blanche that, you know, you give us something in confidentiality that we won't share it? I don't know. I'm interested to hear what Ashley has to say about that. Because I'm going to take that as my legal advice, Ashley.
Yeah, for clarity, no legal advice is being provided during the entirety of this webinar, just to make that clear. Yeah, no, I think, Rick, you talked on the basic tenets of kind of if someone's providing information to the organization. I don't have much to add on that. Obviously, there are additional considerations if it is a professional standards investigation, because there are specific protections for those specific files. So if it is a public complaint, they're treated differently than, you know, a standard police file at times. You know, but there is also public interest immunity on our files as well. So outside of the LA FOIP process, there are protections on police files for that very purpose. So we just can't share a file and disclose a witness or someone that provided police information. That's in place for a specific purpose. So I'm not 100% clear on the question. I think it's probably related to a very specific set of facts that we don't have. But all of those files, every LA FOIP request is very fact specific when it's involving an investigation or really sensitive information and things like that. And even outside of that LA FOIP world, even if someone's requesting it through a court action or just generally, there are specific requirements that have to be met. Police just can't hand over a file. So there are protections in place, both in LA FOIP and outside, with the immunity privilege as well on police files for that very purpose.
Mm-hmm. And from our, sorry, go ahead, Rick.
I was going to say, and when all these presentations that occurred this week are on your website, you might want to go back to Diane's presentation, because she kind of talks about this, and I think in her presentation and articulated it better than I did.
Thanks, Rick. Yeah, and I think just a closing remark on this question. And of course, being from the oversight body, we can't give any advanced ruling, and so we definitely can't say yes or no. But it's really important, who are we dealing with? Because these access to and privacy laws are very specific to the organization in question, right? So police services, LA FOIP applies to them. If it's a government institution like SGI, it's FOIP. And if we were dealing with personal health information, there might be some HIPAA application as well to certain organizations. If none of those apply to you, you still have to ask, well, does the federal law PIPEDA, which is now, C11, and it will be something different soon. But if not, then maybe there isn't an access and privacy law per se that you can point to that says, yes, we can withhold that. But that is a whole nother session for a whole nother day. Okay. So now I want to switch gears a little bit, and we did, just hint at this at the very beginning too, but internal investigations involving employee or member snooping. So from our experience, generally if an individual is, experimenting with looking around at information that they shouldn't be, they generally start with themselves. So they will look up their own information, and then they'll slowly extend that, and it will be friends, family members, and coworkers. So it's pretty predictable, that if you find somebody that's looking up their own information, that, it may be broader than that. So what do you do to deter, detect, and investigate it? And what are some of the cases of employee snooping that you're presently dealing with or have dealt with, if you can talk about the specifics? And we're starting with Ashley this time.
Yes, so we have annual training for all employees, and part of that training, we do include police-specific examples where individuals have been caught snooping or breaching their legislation and the penalties that were faced by those individuals. So, that's clearly covered in our training every year. We also have mouse pads where it has access and privacy tips to kind of constantly remind people about good practices, and also in our internal website as well on the front page. You can, go and refresh yourself on access and privacy tips as well. So we also have an auditing process. We have a standardized way of handling investigations so that they are consistent and that, people know what the process is going to be. I can't speak to any specific cases. I know Rick has some public cases that he can discuss, but generally we are on an annual basis reiterating that snooping is not appropriate, and obviously appropriate ways to deal with information in the organization under the legislation.
Okay. So Rick, what about you?
Yeah, we pretty much very similar. The training, everybody that works in this building receives FOIP training, so that they know what's right. They know right from wrong. Basically, it's spelled out, and we document that so that nobody can claim they were unaware. We also in that training we talk about that it's the privacy and the protection of information is everybody's responsibility. It's not just the heads or the coordinators' responsibility, though we do have specific responsibilities and accountabilities. Everybody in the organization has a responsibility. So if they witness a breach or if they suspect a breach, which snooping is, it's incumbent upon them to bring it to the attention of either the head or the coordinator. You know, these, one of the reasons we set, as I said, one of the reasons we set our program up the way we did was so that it's a smooth transition to an internal investigation. Because one of the problems we have with snooping is when you've got a professional ethics and standards type of unit, they want to catch somebody red-handed. They want to get the best evidence they can. Whereas under FOIP, we're trying to stop the bleeding, right? We want to contain the breach as quickly as we can, and so that's kind of caused a little bit of an issue, I think, in some regards. But for us, once a breach has been identified, or snooping in particular, we transition right away into containment and investigation. We do the same thing. We do routine audits, and if we notice sort of patterns that are sort of inconsistent with a business purpose, we bring people in and ask them to explain explain their habits, I guess, their viewing habits. The other thing I think everybody has passwords to make sure that the people that are at the keyboard are actually the people that the computer is telling us is looking at that information. So that's another kind of issue. You know, and finally, the big thing we've done to sort of deter it is you need determination, right? You have to be prepared to investigate this wherever it takes you, and then implement the appropriate punishment. Our chief is on record. If anybody's ever heard Chief Barraza talk about policing, one of the things he is adamant about raising is that we're a consent-based policing model. Now, we police with the consent of the population. So the citizens need to trust their police service. They need to have full faith in us, and this FOIP provides that. So if you've got somebody that's violating FOIP, how do you continue to build trust with your community? And if you can't build trust with your community, if the community doesn't trust your actions, how do we keep you employed here with our police service? So we've been pretty clear that if you violate FOIP at your own risk. If you're going to look at records that you don't have a business purpose to look at, you do so at your own peril. We've terminated 3 people, 2 specifically for snooping, and 1 for violating. It was snooping as well, but he was using the system to sort of make sure we weren't onto him, for lack of a better term. He was monitoring himself to see if there was citizens' complaints against him, and he was monitoring 2 superintendents, one in charge of FOIP and one in charge of professional standards, to see if they were investigating him. So, the 2 that we did let go, the 2 civilian members that we did let go, in that case, in both cases actually, that it was triggered by members internally that thought there was something inappropriate being done and brought it to our attention. And then an investigation was launched. And when we brought the people in to explain what it was they were doing, we realized this went from bad to worse real quick. One person basically, as I've said before, it's like they got the keys to Area 51 and they just couldn't help themselves. They wanted to make sure they got to see the saucer and the alien bodies. They started looking up all sorts of interesting cases over the years, and family members, and and in a lot of cases, I don't think those family members would have been very keen on them looking at the reports that they were looking at. They had no involvement, so there was really no reason for them to look at those. In the other case, a member civilian member with access looked at information to see who an associate or family member was dating, and released some information that was covered under the Young Offenders Act, which is a huge no-no. And so at the end of the day, there just was no room to for these people to continue their as employees. We have had a member who was looking every year, would look at the personal records of their teammates for the purpose of gathering their birth dates so that they could be the birthday person. And that person was put on probation. You know, at the end of the day, you also have to measure the harm that is created, and you have to have a sentence that's appropriate. And so in this case, we felt that probation, a lengthy probationary period, was the appropriate way to go. So you know, we're not exempt from having people, you know, do things that are potentially embarrassing to our organization. And you know, unlike other organizations, we actually polygraph everybody. We polygraph our civilian staff, we polygraph our members. So these are people that have gone through a fairly extensive hiring process, and then they're trained on top of that. And even when they're told, don't do this, they chose to do it. The birthday one was to me was crazy, because I actually taught the course, and I have 7 children, and so one of them, we have twins, so I have to remember 6 birthdays. And I tell guys, I have to remember 6 birthdays, and I'm not really able to do that. I can remember months, but I can't remember dates. So I used to use our system, you know, pre-FOIP, so I'm okay. Well, not really, but anyway, I would, if I forgot a birthday, I would look to see, and just to get the birthday. And I said, now I can't do that. And I shouldn't have been doing it in the first place, but I definitely can't do it now. So don't do that. And I also say, you know, if your girlfriend, or if your son brings home a girlfriend, using our computer system to see if she's, you know, if she's mother material for your grandkids isn't the way to go here either. And then literally right after having the course, that person went and checked the birthdays after specifically being told, do not do this. So I mean, it happens. You just have to be diligent. And you know, as Ashley says, it takes resources, right? These things aren't done easily. You know, there's no computer program that I'm aware of, and if there is, somebody give me a call and let me know, that has an algorithm that will detect snoopers.
Well, and one thing too that comes up in light of what Rick has been mentioning is that if the temptation is always there, people are more likely to want to snoop. So we've also found that we can change the level of access that individuals have. So instead of everyone having carte blanche access, if you only need access to X portion of a particular database for your position, then you're locked out from access beyond that. And so that way people are only accessing what they absolutely need to do for their job. And I guess if they still attempt to snoop or do something like that, then obviously you've got a problem, but at least you're taking away potential temptation, because they just can't access something that they shouldn't be accessing. So that's one way, if it can be facilitated through your IT department, to hopefully mitigate any potential snoopers as well.
And I've always said that it's, you know, when it comes to this, it's important for people to know what you'll tolerate, but it's more important for them to know what you won't tolerate. And so making sure that everybody understands very clearly that you know, violating the access provisions will most likely result in your termination. And then we've demonstrated that the chief has demonstrated that he's prepared to fire people for violating this legislation. That sends a message to the whole organization. When this first happened, and these happened fairly quickly in time frame to one another, when I would go into the communication center, for instance, and ask to speak to somebody, ask them to stop into my office to speak to me, you know, some people actually broke out in tears because they thought, you know,
they're in trouble.
It had nothing to do with FOIP, you know. So, but I mean, it drove, you know, when you see that somebody violated the act and you see what the consequences are firsthand, it serves as a message to the rest of the community that this won't be tolerated.
Mm-hmm. Yeah, so it's really that combination of all of what you said too. Everything from the training, making sure you're clear on your messaging, working with your IT departments, proactive auditing, doing those investigations, but then the consequences, making sure that they're there. Because if there's no consequences, what's going to keep people from being tempted and do it again? So I think you're sending a very clear message.
And you know, right in the training, we make it very clear that these are you know, all cards on the table. These are potential consequences. We're very adamant that, you know, again, consent-based policing. And this legislation is all about allowing the public access to validate your integrity of your institution. And if you're violating that very act, that's specific purpose is to build integrity and build trust in your organization, how do we keep you employed?
Mm-hmm.
You know, violate it at your own risk.
Mm-hmm. And we talk about the duty to protect in LA FOIP. This is doing exactly that. You know, it's multi-layered approach, looking at the physical, administrative, and technical safeguards, and making sure that everybody knows what the rules are and the consequences. So I think in that respect, you know, looking at my next question, which was 2 years in, a little bit over 2 years in, you know, reflecting on what went well, what didn't work so well, and what's work in progress. Well, clearly, you know, you've had some successes. What are some areas that are still works in progress, Rick?
Well, yeah, I mean, I think the plan, I think our program was successful in that regard in changing some of the previous behaviors. We're continuing to evolve our program, and with continuous training, I'd like to see a little bit more in the continuous training of our members and documenting that training as well. 2 years in, you know, on a personal level, I'd love to see the 30 days change to 30 business days, because I hate, those are pretty tight. You know, when you're doing this on top of some other stuff, it's those can be some pretty tight timelines, but I understand why. One of the things, you know, the need to document stuff right off the hopper, and to have our front line people recognize that this is a FOIP issue, so that we can start that, especially when they're taking in requests, access requests, having that right at the beginning so that we can make those deadlines. I've had a couple where, you know, somebody gets it and they think it's, you know, might be Stitchcomb or something else, and it goes to another branch in the organization, and then 4 days later somebody realizes, oh, this is really FOIP, and they give it to me, and now it's day 5, and it doesn't sound like much, but that's a lot when you're trying to get everything done in a 30-day period. So, you know, documenting everything has been another concern, I guess. For me, documenting every effort, you know, your calculations, phone calls with the applicants, all that stuff, because, you know, when people don't get what they think they were going to get, perspectives and perceptions become a little bit more transient, and things can get twisted pretty quickly. So being able, when the Privacy Commissioner's office phones to say, hey, what's up with this, being able to have a really good written record to refresh your memory on what actually happened is vital. So that's something I'd like to see picked up. The other thing, I would say that I'd like to see more. One of the things that we're not really great at yet are privacy impact assessments. I know Ashley talked about that. You know, still here in Moose Jaw, that there's things that are going on, and I'll hear about them at a meeting and realize, like, you know, that has an implication to our privacy our privacy program. And, you know, you're playing catch up, as opposed to having somebody come to you with an idea and say, can you look at this and see if there's something that we need to focus on or should be concerned on. So that's sort of one of the areas that we're falling down a little bit. Again, yeah, I think that's probably the other thing I think for the future. I think it was in Saskatoon, I got to hear somebody talk from the provincial archives. And, you know, policing, we have a lot of records about stuff and things, right, where people are involved. And we don't really think about the, you know, our records as being sort of historically relevant. And we don't really think about archival of our records. And the thing that makes me think about that is, and I think it was World War I. I think I might be wrong on this. Maybe it was World War II, but I think it was World War I. The last Canadian soldier to be killed in World War I had been spent time in our drunk tank here in Moose Jaw, Saskatchewan before he shipped off overseas. Now, if somebody hadn't have saved that record, when a historian was researching this guy's life, they might not have had that. We might have thrown it out, you know. I don't know what the retentions were back in 1910, but fortunately they didn't generate a lot of records, so it ended up being saved for a long time. But you know, there are people that say, well, gee, you know, it might portray him in a bad light to know that this fellow was held in police cells for being intoxicated. But for me, you know, it's a bit of a human connection that here's a guy, young man who is in the big city of Moose Jaw, Saskatchewan, the most notorious city in Canada, and around that time frame, it would have been along the lines of the little Chicago of the prairies. And before he ships overseas, he's out doing what young men probably did back then. And there's a written record of it here, and it doesn't. The record itself is insignificant, but when you put it into the, you know, the timeline of this person's life and ultimately his death, I think it adds a little bit of to that tapestry of what this guy's life was like. It gives you a human connection. We don't think about stuff like that. We think about, you know, we need to save this for X number of years because of evidentiary purposes or stuff like that. We really don't think of any sort of the historical impact that things will have. So I don't know if that really answers your question, but that's sort of what I see for our future.
Well, it definitely shows the range of types of information and how far back it goes and how of interest it is, you know, to many different people. And that's why I get so many access to information requests, even from journalists and family members and others, because obviously somebody cares, right? There's always going to be that ongoing interest. And just to follow up on one of the topics you said too around documenting everything in case our office needs it. You know, I'd like to say if we were in a review situation or a breach of privacy investigation, we just take your word for it. But we do look for any kind of records or information that can independently verify what it is that you're telling us. Just to be fair, of course, because we're not going to take just the applicant or complainant's words. So, you know, what you can provide to us in that form of a submission or an investigation report really helps to make the case, meet that burden of proof, and to demonstrate that, you know, what you're saying is accurate. So pleased to hear that. Ashley, what about your experience?
Well, as soon as we found out we were falling under the legislation, you know, it became a big focus. And so we ended up having roughly a year and a half to prepare. And it was a provincial effort to, you know, everyone was working to be consistent across the province to make sure everyone was trained. So honestly, the transition, I think, was as seamless as it could have been given the circumstances with kind of how big of a transition this was for the policing organizations in the province. Obviously, there was still a learning curve and things like that, but, you know, everyone had a program in place, their policy, everyone was trained going into legislation and things like that. So I think because we had that kind of year and a half to prepare and do that, I think the transition actually went very well. I've already talked about, I think, the works in progress already with the information government, the agreements and all of that kind of thing, body-worn cameras. So all of that's coming along. So I think the main thing is that we were prepared. There was a lot of effort put in before the legislation came into place. You know, we've got great staff that are working in this very highly specialized area. So I think or at least I hope that we've done everything possible to do it right. Does that mean everything is done perfectly the whole time? Maybe not, but I think there was a commitment from the police services across the province to ensure that to obviously identify its importance and to make sure it was done properly. And hopefully we're successful in that. But I know at least in Saskatoon, you know, it wasn't like, you know, in the year 2000 when everyone thought everything would stop, you know, January 1st, you know, January 1st, 2018, you know, nothing stopped, you know, we were able to kind of continue on and do the important work that we do, but still take on this new component, so.
Mm-hmm. And I think we have sorry, go ahead, Rick.
I was just going to say, Dan, I guess you know, the big learning curve for me was, you know, we were trusting all these other bodies, public bodies that were already under legislation to be protecting our information and to be sharing information with us in compliance with the Act. And that hasn't always been the case. And then it's even more surprising that when we bring it to their attention and all we want to do is become more compliant and have a more compliant relationship, it's almost like they're resistant to doing that. And so that, you know, that's been sort of a big lesson for me, that, you know, not everything is as good, is as rosy as it seems when you start looking, you know, hey, we're sharing information with this branch of the city or whatever. And then you look at, well, where's, you know, at what point did we ask you to do this? Nobody seems to know. And what agreement do we have in place? And what are your policies for protecting the information? And then when you really start drilling down, you realize they should not only, they don't need it, let alone should they have it, kind of thing. So that was you just can't, just because it was done that way in the past, you can't accept that it was being done for the right reasons. So
Mm-hmm.
it's,
I think that's what's really key with the whole discussion that we're having today, is emphasizing that need for the authority to do it on both ends, right? So, you know, if there's information sharing, somebody's collecting, somebody's disclosing, and there has to be that authority on both ends. And, you know, police forces, you've only been under LA-FOIP since January 1st, 2018, and you've come in contact with information for a variety of purposes, right? And you know, that institutional memory. So there's been, you know, a lot of information that, you know, like I said, maybe was handled a little bit differently in the past, but now really there's that focus on ensuring that everybody understands the authority and questioning it and thinking maybe it's not so appropriate in this case, and we're not going to continue with these information sharing practices. And so on that, just one of the comments that we had, I think it's kind of a comment, kind of a question, so I'll read it. Interested to hear thoughts around members searching and reviewing investigative files for general awareness to crime trends in the community that they have no investigative interest in. So I guess it's just looking, what's the authority to just look for trends versus, you know, having to have a need because you're involved in the actual investigation. I hope I'm getting that right.
Rick, do you have comment? I know that this came up for us early on in the legislation. The answer is unfortunately no, you can't unless you have a work purpose to look at that file. Crime trends, you can get that information without having to access all of that personal information and the entire file. I know that there was a culture of reading files just for the sake of reading files to gain an understanding of maybe how an investigation took place, or you know, maybe it was an interesting file, and so people said we should still be able to read these files because we can learn from them. And so we said, well, unfortunately, unless you have a work purpose that allows you to access those files, you just can't go and read any file in the organization. Now, if you need to learn something from the file, or there's something specific for an educational purpose, then talk generally about that investigative process, or that with maybe the investigator on the file. Like you do arson investigations, what are some things that I should be learning or What are some tips that you have or things like that, where you don't have to discuss the very specific information or know every witness on that file or all of that personal information. And that was not popular because that was a very large cultural shift. And I know there's still people that are unhappy with that, but you know, but unless there was an identified work purpose, we said you just can't read any file just because you want to. So, and Rick, I don't know if you encountered that as well, but.
Yeah, in fact, you know, we have in some of the in-house training that we do, especially like in our communications officers, but even some of our younger members, there are a few cases that maybe have a unique investigative angle or something that we want to share. All of those are identified. Those cases are identified, and where we can, we've printed it off with the identifiers so that you don't know maybe the names of everybody involved, but you can get the you understand the investigative technique applied and how it was helpful. The ones that we use for those cases that we do use for educational purposes that we allow access to on the system that are not redacted, those are cataloged so that if a member looks at them, we know why they're looking at them. But they're specifically identified, and there's a handful of those. As far as just randomly looking up stuff that has no investigative value to you, that would be, yeah, I would agree with Ashley. It's taboo.
So we've talked a lot about access and privacy, and we had some more questions that speak to, you know, access and privacy related issues, but this is back to the technology. And, you know, you said the word body cams earlier, Ashley. So now we actually have a question from our participants. So here we go. How are police services working through the process of body cameras through a lens of protecting both police members and the public? Now, given the new realities of BLM, Me Too, TRC, and the impacts of social media. So Ashley, what are your thoughts?
Well, in Saskatoon, we're still in very, very early days of kind of the body-worn camera process, but we're not the first ones in the country that have gone through this. We're definitely not the first police service. So I think at this point, there's a lot of education, a lot of understanding of what body-worn programs are happening across the country and elsewhere. You know, we're in such early stages, I can't really speak specifically to exactly how our program will work or what that will entail. But I know that, you know, obviously any type of body-worn camera program has a lot of consultation, and obviously it has to comply with law and legislation, evidentiary requirements for court cases and things like that. So you're not just going to be able to strap a camera on an officer and have them just do whatever they want with it. So I think that especially in the current environment, that people are very cognizant, obviously, about privacy, about any kind of sensitivities and things like that. And I think obviously, you know, down in the United States, body cams have been around for a very long time. And I think there's a lot that Canadian police services have learned of what not to do with body-worn cameras from our counterparts, and there may be some good things as well that they can learn, but it's not recreating something from scratch. And so I think that a lot of it is taking what's out there and improving it, hopefully even further.
Mm-hmm. Rick, anything to add?
No, not really. I mean, you know, the body-worn cameras, it sounds great that, oh, you're capturing everything, but the problem is it's going to capture everything. And I mean, anybody that's had to redact video knows what a nightmare that is, and the cost and everything else that goes along with it. So yeah, so for me, it's a wait and see.
I think I was lucky because last week there was a whole panel discussion on this for Privacy Day. And what we learned, and I think it was just released, was the policy procedure guidance material from the Toronto Police Service. And so they've really worked hard to get their head wrapped around the issues and worked with the Privacy Commissioner's Office in Ontario to really come forward with a very thoughtful process in terms of considering everything from human rights to how they're going to handle access requests to protecting privacy, and there was discussion about the power imbalance potentially in terms of when the camera is turned on versus when it's turned off, and so it was a very thoughtful piece, and yeah, I think it was the Toronto Police Service, so it's something that I'm sure is available on their website, so take a look if you want more information on that. So it's 2:10. We already have we had a couple more questions, but there's one more from participants. So I think we'll shift gears and go to that instead of back to our other questions. Also interested the briefing note practices and what information is appropriately shared with all members related to overall calls for service.
That one's highly operational, Rick. I'll leave that one to you.
Okay.
Yeah, can you repeat that one? The briefing
Right.
note?
Yeah, I'm not sure what they mean about the briefing note practices. Not sure. I thought maybe it was something that the two of you would be familiar with. But what information is appropriately shared with all members related to overall calls for service?
Okay. Well, so our overall calls for service, every day we share those online. They're de-identified, but they're redacted to some degree. But sort of the type of calls we responded to are published on a daily basis. When it comes to briefings, each team is made aware of sort of what the hot topics were for the past 24 hours or longer, if it's a bigger concern. And then it's also done at the individual officer level, like so, in areas of the community. If I'm the East Side guy, for instance, the offgoing East Side guy might share with me, I had this going on last night. You're probably going to get some calls about X, Y, or Z. But that's I mean, there's a purpose for that, right? It's so that there's a continuity in the service delivery. I don't know if that answers the question or not, but
Yeah, I'm not sure. I'm sure we'll probably get a follow-up if we haven't covered it off sufficiently. Another question, any comments on working with Hub? So I'm assuming that's community mobilization.
Yeah, so we have the Hub here, and there are agreements in place to allow for the sharing of information. I think it's consistent with the intent of the Act, that you're sharing information for the purpose of helping an individual, providing a service to that individual. And generally, if there's discussions that are specific to an identifiable individual, the only people that are involved in those conversations are the people that are connected to Hub that are actually relevant to that service delivery. So Hub overall, there's a lot of agencies involved with Hub, but not all agencies would have a need to know what's going on in Rick McKenna's life, but there might be 3 that do. So those 3 would have communication amongst themselves that would be specific to being able to provide a service to Rick McKenna.
Mm-hmm.
I hope that answers the question. It's a pretty simplified version, but.
Ashley, do you have any experience in Saskatoon?
It's essentially what Rick had indicated, is that there's an information sharing agreement with all the Hub partners. So from that perspective, everyone has to comply within the protocols and what's outlined in the agreement. But my understanding is the same as Rick. Someone may be recommended to the table, but ultimately, how they identify as best to assist that individual kind of may involve only several people at the table and vice versa. So, and also once someone is aware and there's outreach that occurs, they have to consent to services and moving forward anyway. So then consent to the individual usually doesn't become an issue once it kind of moves on to that kind of service delivery component. So it's a very comprehensive agreement. So I think they've done everything possible to comply with the legislation and ensure that all of these partners who fall under multiple pieces of legislation, that it's in compliance with HIPAA, it's in compliance with FOIP and LA FOIP as well. So it's actually quite complicated on that front, but they've done a great job because of how beneficial the hub table is to the community. So.
Mm-hmm. And our office actually did an investigation into the hub in Prince Albert. I believe it was back in 2014. And so we took a really good look at the practices at that time, made a lot of recommendations, and there was some follow-up. So we definitely knew that there was actions taken in order to make sure they were as compliant as possible, with the legislation going forward. And there really was a need to know when identifiable information was being shared with those at the table. And it would be going from a larger group at the table talking about de-identified data to, okay, now we know there needs to be some sort of an intervention here. Let's have a sidebar. Let's take only the 3 people with the need to know, and let's go have a discussion and talk about who this is, right? So a very complex program, involves a lot of agencies, but of course, they have a goal and consent based in terms of whether or not there's going to be services that are provided down the road.
And it's serving our most vulnerable people in our community. So it's incredibly important. So.
Yeah, that's actually hit the nail on the head there. This is a program that was set up to catch people that have sort of fallen between the cracks of service delivery of different agencies, and really by coming together and sharing information one-on-one as service delivery people, it kind of allows everybody to sort of stretch their mandate a little bit to make sure that these people aren't left behind.
Okay, so we're at 2:15 and we have a couple of questions left. We had a couple around the actual access to information process, and we might as well touch on that one more time. And the 2 questions, I'm going to put them together. So one was, in terms of the access to information process, applicants aren't necessarily always the easiest to work with for a number of reasons, including sometimes there's hesitancy to come forward and actually explain what it is they're looking for, because they don't necessarily want to share that because there's that lack of trust. But also they don't understand the record management practices, right? What do you have? How far back does it go? And so there can be a lot of problems there. Plus, a lot of times they're asking questions. So what do applicants need to know in order to make it easier for everyone? And also, what do you need to do in order to make sure that you're meeting those tight timelines? Because 30 days comes and goes just like that. And Rick, I know you're chomping at the bit for this one.
Well, it goes back to what I said initially, but the first thing you need to know is that the person you're making the application to is constantly trying to do the right thing. They're there for the right intentions. And if you think back to what I said, becoming involved with this LA FOIP has exposed me to some people that understand very well the significance of what they're doing, and they truly believe in it, and that's infectious. Even to somebody like me that's been around for over 37 years. So these people are trying to do the right thing all the time. And if one of the things, I think I probably know what this person's implying. One of the things I've noticed is we get people that apply for things, and I don't know if if you're trying to disguise what your true intent is, then you're likely going to get exactly what you ask for. But because you've disguised so well what you really want, you're not going to get what it is you really wanted or really need. The best way to get what you really want, what you really need, is to have an open and frank conversation with the person that's running the program, or the person that's going to be responsible for putting your package together, right? So either when they call you, explain what it is that you're trying to accomplish, what your intent is, or what you're actually looking for, because we, as you said, we understand our records, and so how you've asked for it might not be the right way to go about getting the information, and actually how you've asked for it might not even be the right way to get it. I've mentioned that we've had people come in and they want to do a FOIP thing, which is going to cost them money, and it's going to be redacted. They're not going to get the information they need, but it's because they want to defend themselves at a trial or whatever, speeding ticket, whatever. And actually under Stinchcomb decision, you're allowed to get that basically unredacted version of events. I mean, the personal information of addresses and stuff like that is going to be redacted of witnesses, but you're going to actually know who's going to say what about you in your court case if you apply under Stinchcomb. But you won't know that if the average person doesn't know about Stinchcomb. But if they come in and they indicate what it is they're actually looking for and why they're looking for it, they're going to get put in the right slot, and they're going to get the information that they need, and be put in touch with the person that's best able to help them. I don't know how much clearer I could say that, but it's at some point it's about trust, and if you can get to the quick of what it is that you are looking for, that also helps the people that are doing it, because they can eliminate all the clutter and get to the specifics. Police records are about events. That's the difference between policing and education and health, or banking records, or whatever, what have you. Those are about a specific person and that person's file. Whereas police records are about an incident that involves people. And your role in that incident might be minuscule. So when you make an application for everything the police have on me, and really what you want to know is, I want to know about this investigation of this B&E when I was broken into. And now you're going to get a report where you called in about your neighbor's domestic dispute. Well, the only thing that identifies you to that file is you were the complainant. You weren't involved in the domestic dispute. You don't even know who the neighbors were, and all that stuff has to be, somebody has to take the time to go through that material and redact it so that they can provide it to you. But if you said, look, I'm looking for a time when I reported a B&E and whatever happened with my investigation, then we can go to that specific report and get you that information, and likely have the time to talk to the officer to find out if there was anything that wasn't in the report that we should know about, that was written in their notes or whatever. Does that help?
I think so. Ashley, what about you? Anything further?
No, I think Rick covered it off. So I don't have anything else to add.
And you're right, in terms of the timelines, if you can talk to the applicant and focus it, get to the heart of what they're really looking for, you're not going to have any problems meeting your timelines. And if they're satisfied, they're not going to request a review of our office. So I think it's a win-win for everybody involved.
Yeah, the thing people don't understand is, like, people are interested, I guess the nature of the work, people are interested in what's going on with the police. And Ashley talked about, public interest and interest from the media. Because people are interested in policing, the media tends to be interested in policing. So then, they're asking for information. Sometimes just regular old citizens are, hey, I see the police were down the street from me. I can put in a FOIP request and find out what was going on. No, you can't, because it's not your personal information, and you don't have a right to know that. So just having that upfront conversation, saves a lot of headache, and could save, people a lot of anguish, because you got to pay your $20 to put your application in, and we're not returning that $20 if at the end of the day we can't help you. So.
Great. So we're almost out of time. I'll give you guys one last opportunity for last thoughts. Ashley, let's go to you.
I think we've covered a lot of ground today, and I would just say that, transparency, managing expectations, and continuing to work on improvements are pinnacle. and that police services are working hard to ensure that access and privacy are a priority, and hopefully we'll continue to be able to keep improving and keep learning as we go along. So
Great. Rick?
Yeah, I just reiterate, policing in Saskatchewan is a consent-based policing model. And the only way it works is if the public are 100% confident that the police that are protecting them and serving them in their communities are doing the right thing. And LA FOIP is really the biggest tool they have to be able to verify that by accessing their personal information. So when you make these requests, you have to be confident that we're going to do everything we can to provide you the information that you need or are looking for, because we're confident that it's going to demonstrate that we are ethical and dealing with you with integrity. I don't know how much clearer I can be on that.
And it's so clear that both Saskatoon Police Service and Moose Jaw Police Service have gone to great lengths to get everything, their houses in order and be organized and have their processes and procedures that are solid, so that citizens can exercise their rights. They can make access to information requests and make privacy complaints, and they're going to be handled appropriately. So thank you for all of your efforts and doing more in 2 years and a bit than we've seen from some organizations that have been bound by the legislation since 1993. So thank you very much. And thank you for the discussion today. I'm hoping that our participants took a lot away from this session, even if they aren't actually part of a police service, because there's a lot, I think, that can be applied across the board, regardless of the type of organization that you work. So just to wrap up, a reminder that immediately after we shut down this webinar, that post survey is going to pop up. Again, please give us your feedback. It's how we improve and we do better next time. So thanks to all. And this is our last webinar for the week. Stay tuned till next time.